Let's turn our attention now to politics as we bring you the latest on tribunal judgments in the country. The Governorship Election Tribunal sitting in Jos has upheld the election of Governor Caleb Mutfwang as the duly elected Governor of Plateau State. The All Progressives Congress petition against the PDP Governor was struck out for lack of merit. TVC News Plateau State correspondent Funam Joshua reports.
Supporters of the People's Democratic Party in Plateau State are celebrating the outcome of the Governorship Election Petition Tribunal. The opposition All Progressive Congress Party in the state had filed a petition seeking the nullification of the governorship election on the grounds that the PDP in the state did not have a structure in place to contest the last general election. It argued that a court order directing the ruling party in the state to conduct their ward congresses was not obeyed by the PDP. The judgment, which lasted for a few hours and was presided over by the lead judge, Justice Irele Ifene, it struck out the claim by the APC for lacking merit and upheld the election of Governor Caleb Mutfwang as a duly elected governor of the state.
The tribunal decided that it is not in the place of the petitioner to start stretching its neck from his own compound into another man's compound to see what is happening there. That means that the petitioner has no locus to challenge the nomination of the governor who is in another party from that of the petitioners. And that too, the issue of nomination is a pre-election matter. That means that it is an issue that must have been decided before the election. And so the tribunal had no jurisdiction to look at that. All the three issues canvassed, raised and argued before the tribunal were resolved against the petitioner. So you can say it is a match that ended 3-0 in favor of the governor.
So this is to let everybody know that all hope is not lost. The first bus stop has been passed. We are going to the next bus stop that is filing an appeal to the Court of Appeal, where we are sure that they will take a more in-depth look at all the facts and the law.
That which Plateau people yearn for will be sustained and maintained by the courts. Therefore, I'm very happy and I'm proud of the system, and I'm sure the system will continue to pull us through.
Supporters of the People's Democratic Party celebrating their victory at the tribunal today. Aggrieved party are expected to seek redress at the Court of Appeal. Funam Joshua, TVC News, Jos.
Now, for further perspective on the tribunal judgment, I am being joined on the news by a legal practitioner and an electoral administration expert, Polycarp Data. Good to have you join us.
Yeah, good evening. Thank you for having me.
What's your assessment of this particular judgment?
Well, I want to start by saying a big congratulations to the people of Plateau State, His Excellency, the Executive Governor of Plateau State, Barrister Caleb Mutfwang. What has happened today is a trite restatement of settled principles of law by the Supreme Court and numerous pictorial judgments that the election petition tribunal look at pre-election matters, events that took place before the election. And indeed, the petitioners, that's the All Progressive Congress, and their candidate challenged the nomination, the validity of the nomination. On the premise, there was a court order that was given in 2021 by Justice S.P. Gang of the Plateau State High Court, ordering PDP to do a repeat Congress. And indeed, PDP obeyed. But the petitioners went to court challenging the qualification of His Excellency Barrister Caleb Mutfwang, that he was not duly nominated because his party, that's the PDP, didn't have to have nominated a candidate. Issues were joined and evidences, of course, the fireworks took place at the tribunal. But the tribunal, in a well-considered judgment and in line with precedents, that the election petition tribunals do have a jurisdiction to look at pre-election matters, because matters are spent by Section 285, sub 14 of the 1999 Constitution. You have only 14 days. And in any case, only an aspirant, a member of the political party who was cleared by the political party, who contested the election with His Excellency Barrister Caleb Mutfwang, would have the locus to challenge his nomination. And in any case, that person would have only 14 days to do that. That is on the first ground of the petition. The second ground was an issue of non-compliance, and they raised issues of overvoting. But of course, they couldn't prove that. They brought an expert, which is a court, which is a tribunal in its wisdom, of course, based on the Evidence Act, stated clearly that his evidence is worthless because he's an interested party. And they raised a number of issues in almost over 300 polling units. And they brought just less than 30-something or so polling units, witnesses, to cover those polling units. And of course, we know the courts have stated non-compliance, you must prove it polling unit by polling unit. So that is just, in summary, the gist of what really took place in Jos and what the tribunal decided to the joy of majority of the voters on the plateau.
And I want to pick your brain on all the other tribunal judgments we've seen, whether it's in Enugu or in Kano, because we've seen a situation where it's either the judge is resolving all of the issues in favor of the petitioner or in favor of the respondent. What's your thought on all of this? Is it that, look, those who are petitioners are not doing enough to pursue their cases or prove their cases? What exactly is going on?
Well, election petition is sui generis and is unique, is of a special character. It's not like your everyday civil procedure or civil proceedings. So it requires some form of diligence and some form of understanding of the processes, of the nature of what you need to prove, the parties you need to join in the petition, your pleadings, the nature and the quality of the witnesses that you ought to bring to prove whatever allegation. There are special procedures for proving each and every allegation in election petition, whether it's issues of qualification, non-compliance, or whether it's issue of practices where you need to prove beyond reasonable doubt, because it raises issues of criminality. And then when you say that the respondent did not win majority of the votes, there is a procedure. Each of the allegations have special procedures by which you can prove them. So if you don't come with the required witnesses, the presumption of regularity in favor of all results declared by the electoral body, that is INEC. So the court, of course, will, if you don't meet the minimum standard of proof or the quality of the evidence that you bring before the court does not meet up with what is expected. Does not meet up with what is expected. Of course, the tribunal will not be convinced, and of course will throw out your petition. But we've seen a number of results overturned, and we may have our misgivings, but of course the Court of Appeal is there.
And most of those who have lost out have said, look, they're going to the appeal court. We'll see how it plays out for all of those who have decided to go to the appeal court. Thank you so much for, I'm afraid we do have to leave it there. Thank you so much for talking to us, legal practitioner and electoral administration expert, Polycarp Datao.